your company is growing. Other companies are not doing as well. Your sales force, your inventory, you're moving, you're excited. And then something happens. One of your employees leaves. But the unthinkable happens. They set up shop right down the street from you. They take all of your good ideas and they go and they create their own company. Or they work for a competitor and take all of your ideas and basically give it to your competitors. You remember that you signed an NCND agreement. It's called a non-competition, non-disclosure agreement with that employee. And now you want to enforce it. The question for today is this: are NCND agreements applicable to the employment relationship? And this is what we're going to be going over today. But before we begin, I want you to go to the first video that basically says this video here does not create an attorney-client relationship. Let's go over it. The history of the NCND agreement is this. It's easily stated in Business and Professions Code 16600. Since 1872, relatively unchanged. Every contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind is to that extent void. Now, what does that mean? California Business and Professions Code 16600 says any contract, if you're trying to restrain someone from getting gainful employment, that's going to be void. That's been the position of the state of California. However, why are NCND agreements so popular? Well, they're popular for several reasons. First of all, not everybody wants to litigate an NCND agreement. Secondly is, a lot of people really are just trying to test the courts. They basically say, you know what, we don't know if it's valid, but we're going to put it before the court and let a judge or jury decide the NCND agreement. There are some exceptions of the NCND agreements that some courts have allowed, and that is NCND agreements that have been narrowly drawn. So what the courts have said is this is called a narrow exception. If you draw the NCND agreement so narrowly that it doesn't impede someone's employment, that's been okay. That's been okay. However, the Edwards versus Arthur Andersen case came out in 2008. Basically, Edwards II, who was a CPA at the firm of Arthur Andersen, sued them saying that their NCND agreement violated Business and Professions Code 16600. And the California Supreme Court agreed. It totally blew away all the attorneys. We totally couldn't understand why that had occurred. The court did say that there is no narrow restraint exception within NCND agreements. So if you draw it narrowly, you know what? It's still a violation of the law. Now, post-Edwards, after the case of Edwards, some courts have said if the NCND agreement is based on trade secrets, then that would be enforced against a former employee. So what is the conclusion? The conclusion is this: restructure your NCND agreements as soon as possible. If your NCND agreements are very broad, you need to restructure them. Not only must you make them more clear, but you need to make sure that you write it in accordance with trade secrets. If you do not write your NCND agreements as a trade secrets clause, you're effectively inviting a lawsuit where someone's going to sue you for an unlawful business practice under Business and Professions Code 17200. Thanks a lot and take care.